Later this evening, the Senate will vote on the Defend Trade Secrets Act, a bill that will enable U.S. businesses to protect their trade secrets in federal court. Senator Chris Coons and I have been working on this legislation in a bipartisan way for nearly 2 years. So it is really satisfying to see the Senate poised to vote on this important bill. To date, the legislation has 65 bipartisan co-sponsors, including the distinguished Senate Judiciary Committee Chairman Chuck Grassley and Ranking Member, the distinguished Senator Pat Leahy. I appreciate their support for this bill. I also commend our House colleagues, Representatives Doug Collins and Gerald Nadler, for their tireless efforts, and others over there as well. They've been invaluable partners in advancing this legislation in the House of Representatives. Working under the capable leadership of my dear friend, House Judiciary Committee Chairman Bob Goodlatte, we've come together to right an inequity facing U.S. businesses by creating a civil remedy for trade secret misappropriation. Trade secrets such as customer lists, formulas, algorithms, software codes, unique designs, industrial techniques, and manufacturing processes are an essential form of intellectual property. Other forms of intellectual property, such as patents, copyrights, and trademarks, are covered by federal civil law. Trade secrets, by contrast, are the only form of U.S. intellectual property where the owner does not have access to a federal civil remedy for misuse or misappropriation. As a result, billions of dollars each year are lost to trade secret theft, which stifles innovation by deterring companies from investing in research and development. Currently, the only federal vehicle for trade secret protection is the 1996 Economic Espionage Act, which makes trade secret theft by foreign nationals a criminal offense. But this remedy criminalizes only a small subset of trade secret theft and relies on the thinly stretched resumes of the Department of Justice to investigate and prosecute such offenses. One experienced trade secret practitioner told me recently that the Justice Department typically only considers prosecuting cases with more than $100,000 in damages. This is because trade secret investigations and prosecutions are more resource intensive and complex than most other federal crimes, requiring a deep technological and scientific background. Given these constraints, the Justice Department and the FBI are reluctant to commit scarce resources to investigate and prosecute a single matter, especially when the same effort could result in the prosecution and conviction of other federal crimes. Therefore, it is not surprising that in the 20 years since the Economic Espionage Act became law, federal prosecutors have charged only about 300 defendants for economic espionage or trade secret theft. And because these cases frequently involve multiple defendants, this equates to an average of about 10 prosecutions annually. Clearly, current federal law is inadequate in resolving the many challenges our businesses face in today's innovation economy. State laws have proven inadequate to protect victims of trade secret theft. Since most businesses today operate across one or more state lines, having a uniform set of standards that defines legal protections for trade secrets is crucial. That was the rationale behind creating the Uniform Trade Secrets Act, which sought to achieve nationwide uniformity in trade secret law. But over time, most states have adopted their own trade secret laws. In fact, state laws today are perhaps even more variable in their treatment of trade secrets than they were at the time the Uniform Trade Secrets Act was proposed back in 1979. This mixed bag of differing legal regimes forces victims of trade secret theft to wade through a quagmire of procedural hurdles in order to recover their losses. For example, if an attorney needs testimony from a witness in another state, she must first apply to have her local court asking that it requests the other state to issue its own subpoena for the document or deposition. This process can take weeks, which is an eternity, in a trade secrets case. Under a uniform federal standard, the process would be far more efficient. That's because all federal courts apply the federal rules of civil procedure, allowing attorneys to obtain documents and testimony from a witness in another state without having to apply to that state's court system. Essentially, enabling businesses to protect their trade secrets in federal court removes an unnecessary and time-consuming layer of bureaucracy. Streamlining access to remedies is critical in trade secret cases where an expedited judicial process may be necessary to deal with thieves who pose a flight risk. Unfortunately, once a company's intellectual property is leaked and the information is made public, the trade secret loses its legal protection. Put simply, state laws designed for intrastate litigation and offers limited practical recourse to victims of interstate trade secret theft. The contrast between intrastate and interstate. Maintaining the status quo is woefully insufficient to safeguard against misappropriation. U.S. companies must be able to protect their trade secrets in federal court. The Defend Trade Secrets Act will do precisely that by providing trade secret owners access to both a uniform national law and an ability to make their case in federal courts. Likewise, the bill allows victims of trade secret theft to obtain a seizure order in extraordinary circumstances. This type of order would allow misappropriated property to be seized so that it isn't abused during the pendency of litigation. To ensure that companies do not use the seizure authority for anti-competitive purposes, this legislation requires those seeking redress to make a rigorous showing that they own the trade secret, that the trade secret was stolen, and that third parties would not be harmed if an ex parte order were granted. The bill also allows for employees to move from one job to another without fear of being wrongfully charged with trade secret theft. Mr. President, in addition to the overwhelming bipartisan support among my Senate colleagues, more than 50 companies and associations have endorsed the Defend Trade Secrets Act. Leaders in the technology, life sciences, manufacturing, energy, automotive, agricultural, and telecommunications sectors support this bill, among others. Many letters and opinion pieces have been written in support of the bill. Let me just briefly share some of the comments from our nation's business leaders. In an op-ed published in The Hill, Artie Newhouse from the National Association of Manufacturers states, quote, it was Arik Newhouse from the National Association of Manufacturers. He states, quote, the Defend Trade Secrets Act encourages investment in cutting-edge research and development and will have an immediate positive impact on our innovative sector, ultimately creating jobs and opportunity in manufacturing in the United States, unquote. In a piece published by the Washington Times, David Hirschman from the U.S. Chamber of Commerce writes, quote, the Defend Trade Secrets Act creates a federal civil cause of action that currently does not exist. Creating a new federal civil cause of action will help industry help itself, unquote. In an op-ed in the Washington Examiner, Mark LaRoche from the Intellectual Property Owners Association writes, quote, every day without this law, our companies are losing millions of dollars to trade secret theft, unquote. Victoria Espinel from the BSA Software Alliance writes in the Huffington Post, quote, the Defend Trade Secrets Act would provide that important missing remedy and help usher in the harmonized system that will benefit not only software innovation, but our entire American economy, unquote. Guy Blaylock from the Utah's IM Flash writes in the Salt Lake Tribune, quote, enacting the bill will have an immediate positive impact on innovative companies that create jobs in this country, unquote. In a joint op-ed published in the Salt Lake Tribune, Rich Nelson, from the head of the Utah Technology Council, and Lane Beatty from the Salt Lake Chamber of Commerce write that the Defend Trade Secrets Act, quote, equips business owners with the tools they need to combat trade secret theft, unquote. Finally, Eli Lilly's Michael Harrington and Microsoft's Eric Anderson, in an op-ed published in Forbes, wrote, quote, this thoughtful and carefully considered legislation will adapt America's trade secret regime to reflect 21st century realities and will strengthen this critical form of intellectual property, unquote. I ask consent that the op-eds from which I just quoted be placed in the congressional record following my remarks. Mr. President, throughout my 40 years of service, I've been a part of almost every significant intellectual property initiative that has come before the Senate, from the Digital Millennium Copyright Act, which sought to streamline our copyright system for the digital era, to the American Invents Act, which overhauled our patent system to help ensure American innovators' property rights are adequately protected in the 21st century. Legislating in the area of intellectual property requires patience and perseverance. The bill on which we are voting tonight has been 2 years in the making. Initially, providing a federal standard and civil remedies for trade secrets had little support. It took much effort not only to identify the precise nature of the problem, a problem that amounts to hundreds of billions of dollars in economic losses for U.S. companies annually, but also to develop a solution that could garner the support of virtually all stakeholders. This required soliciting input from a broad range of interests and working closely with dozens of trade associations, affected businesses, and policymakers on both sides of the aisle. The final version of the legislation that the Senate will pass later this evening reflects input and additions from a broad coalition of interested parties. It also reflects a number of instances where a careful balance had to be struck between competing interests. As has been true of several recent intellectual property efforts, the interests of the technology sector and the pharmaceutical industry are not always aligned. The same was true when it came to trade secrets. Yet we worked hard to develop a solution that could meet the needs of both. This balance is perhaps best exemplified by the joint op-ed I mentioned a moment ago, co-authored by the general counsel of one of America's leading pharmaceutical companies and a senior executive from one of America's prominent tech companies. As chairman of the Senate Republican High-Tech Task Force and co-author of the Hatch-Waxman Act, I know how critical it is to strike the right balance such that both the high-tech and life sciences industries can support a bill. We have struck that balance with the Defend Trade Secrets Act. Not only will we succeed in defending the trade secrets of American businesses, I hope the passage of the bill will serve as a springboard to spur congressional action in other areas of intellectual property, including patent litigation reforms. I commend in particular House Judiciary Committee Chairman Bob Goodlatte for his steadfast work on this, in this regard, and I stand ready to do everything in my power to help him in this endeavor. Tonight's passage of fundamental trade secret law reform would be a significant achievement at any time, let alone in the challenging partisan environment we face today. Indeed, today's Senate vote is not only a watershed moment for the intellectual property and business communities, it is also an example of what Congress can accomplish when we put our party politics aside and focus on areas of agreement. Throughout my Senate service, I have always sought, whenever possible, to seek common ground in order to advance public policy priorities that will benefit the American people and the American economy. With this bill, we have done just that. I want to thank Senate Majority Leader Mitch McConnell for leading the Senate in such a way to make constructive bipartisan legislating possible. I appreciate his support for this legislation and his willingness to devote valuable floor time to help ensure its passage. Tonight, we will add the Defend Trade Secrets Act to a long list of legislation the Senate has passed in the last 15 months since the senior senator from Kentucky assumed leadership of the United States Senate. This is yet another example that the Senate is back to work for the American people. I also want to take this moment to thank the many staff members who have been instrumental in getting us to this point. Let me start by thanking my senior Judiciary Counsel, Matt Sandgren, whose relentless determination helped make tonight a reality, and my Chief of Staff, Rob Porter, for his unmatchable leadership in shepherding this bill forward. Together, Matt and Rob have been an invincible team, working hand in glove throughout this process. I personally appreciate their excellent work. I also recognize my superb press team for their efforts, J.P. Frere, Matt Whitlock, and Sam Lyman. I'm also appreciative of my dedicated law clerks, Ryan Carr and Jacqueline D'Esposito. I also acknowledge the important contributions of Senator Coons' current and former staff, Ted Schroeder, Andrew Crawford, Erica Songer, and Jonathan Stoller. There are also several staff on the Senate Judiciary Committee who have been instrumental in helping with this key intellectual property bill. Rita, Laurie, Joachim, Jonathan Nahavi, Alexandra Gibbons, Danielle Catrona, Eric Hansen, Lee Holmes, Lartice Tiffeth, Gary Barnett, Daniel Swanson, Ray Starling, Ethan Aronson, Chad Rhodes, and Sam Simon. I also want to acknowledge the following House staff for their hard work and commitment to this bill: Shelley Husband, Brandon Ritchie, Jennifer Chaudhry, Sally Larson, Jason Everett, and David Greengrass. Finally, I want to thank the many staff members for Majority Leader Mitch McConnell and Minority Leader Harry Reid, who helped make this bill's passage a reality, especially Laura Dove, Sharon Soderstrom, Hazen Marshall, John Abeg, Chris Tuck, and Ayesha Khanna. Mr. President, enacting meaningful public policy and reform in the midst of a contentious presidential election is really something to celebrate. In very real ways, this bill will help strengthen our economy and allow business to grow and create additional jobs for hardworking Americans. I hope my colleagues will join me in safeguarding American ingenuity by voting for the Defend Trade Secrets Act. They won't be sorry about doing that.
Echoing for 2 minutes.
Now,